All rise. The Court of Appeals, Division 1, is now in session.
Good morning. Please be seated. This is the time set for argument in the case of Michael MAGNOTTA versus Stephen SERNA et al., our civil number 16-0712. Each side will have 20 minutes within which to present their arguments here this morning. Appellant may reserve some portion of that time for rebuttal. However, it's up to you to keep track of that time. We have read the briefs. We're familiar with the record. We've conferenced the case. So I think we have a good understanding of the underlying facts and the issues that have been brought here today. So please keep that in mind as you make your arguments today. We are recording the proceedings both by audio and video, and in a matter of days the video will be available on YouTube for anyone who wants to see it. For that reason, however, as you approach the podium to give your respective arguments, please identify yourself and your clients for us. With that, appellant may proceed.
Good morning. My name is Janae Perry-Meyer. I'm from the law offices of Donald W. Hudspeth. With me today is attorney Michael Malin. I'm appearing on behalf of appellants Steve SERNA, Lisa SERNA, and Unify, and one of my clients, Mr. SERNA, is in the courtroom today. My clients urge the court to vacate the November 1st, 2016 order with respect to the injunction and the receivership, because regarding the injunction, the order violates Rule 65's specificity and security requirements. And regarding the receivership, the court had no equitable or statutory authority to appoint a receiver. The court improperly ordered a receiver to wind up the company without first entering a judgment of dissolution. The court improperly appointed a receiver to protect property in which the applicant had no interest. And the court erred in appointing a receiver to conduct an accounting and ordering Mr. SERNA to pay for half of that accounting.
Do we have jurisdiction over these issues concerning the receivership?
Yes.
And what is the basis for that?
The court has jurisdiction pursuant to ARS 122101 because this is an appeal from the appointment of a receiver. Now, this case involves two separate receiverships. The plaintiffs would have you believe that this is merely an order continuing a receivership or expanding the authority of a receivership. But what happened in this case was we had a temporary receivership that expired in September of 2016, and then we had a new permanent receivership entered into as of November 1st, 2016. So we had about a month gap there where there was no receivership in place. And the same date that the temporary receiver was appointed, August 29th, the parties stipulated to continue the hearing that was set regarding plaintiff's application for a receivership. And we did that to give the receiver adequate time to prepare the status report. And we agreed to allow the receiver to remain in place until September 30th. The receiver actually filed his report on September 9th, stating that Icaligo was valueless, had no ongoing business, and that he had closed down the company. Thus, the temporary receivership was terminated 1 month before the hearing on plaintiff's application for a receivership, which is a statutory requirement as well, that there be the hearing. And the permanent order of November 1st is an order appointing a receiver. Now, in the alternative, if the court finds that it lacks jurisdiction pursuant to 122101, the court should exercise special action jurisdiction over this matter because there's no equally plain, speedy, or adequate remedy. The case involves both issues of statewide significance and pure questions of law, and the record on appeal is adequate to allow you to resolve those legal questions for us. And you can exercise that jurisdiction sua sponte, although I believe we've asked for it in our briefs. Okay, with respect to the receivership, The court could have only appointed a receiver in this case pursuant to ARS 12-1241 or 29-785. Now, the court didn't have authority to appoint a receiver pursuant to 12-1241 because the property at issue was not the property of the applicant, meaning the plaintiff had no interest in the property that he sought protection over from the receiver. And both ARS 12-1242 and Rule 66 of the Arizona Rules of Civil Procedure require that the applicant file an affidavit stating which property, the property in which he has an interest that is at issue. In addition, the court didn't have authority to appoint a receiver pursuant to 29-785 because the court had not first entered a judgment of dissolution, which is required under 29-785, before it can order a winding up of a company. Moving on to the accounting portion, the court didn't have an equitable reason or statutory authority to order an accounting. There's no statutory authority for an accounting because this case involves an LLC, not a partnership. The plaintiff would have it be characterized as a partnership because the case law behind partnerships and the statutes governing partnerships are more favorable to them. However, the fact remains that this is an LLC and these are two members of an LLC. Under the LLC Act, a member has the right to inspect the books and records of a company, but no member is required to furnish another member with an accounting. Thus, there's no equitable reason to appoint a receiver for an accounting because Mr. Serra was under no fiduciary duty or statutory duty to provide an accounting under the LLC Act. And regarding Mr. Serra's payment of the receiver's fees and costs, because the appointment itself was improper and ordering an accounting in this case was improper, we argue that ordering Mr. Serra to pay for half of the fees for the accounting was an error as well. Pursuant to that order, he could have been held in contempt or thrown in jail if he failed to make a payment to the receiver for services that were being rendered to the LLC. And our argument there is that if the appointment's improper and the accounting's improper, forcing a member to make payments to an LLC for services rendered is akin to calling for capital contributions or asking the member to contribute more funds to the LLC and disregarding that as a separate entity for that reason. With respect to the injunction, the court's order granting the injunction was not specific enough to put those enjoined on notice of the conduct from which they were enjoined. Rule 65D1B requires the court to specifically state the terms of its order, and 65D1C requires the court to describe in reasonable detail the act or acts restrained without referring to some other document. Now, plaintiffs are relying on the Rebath case, which is a federal case, to support their argument that courts routinely issue injunctions without meeting specificity requirements. But in that case, the court actually did meet the specificity requirement, and they met it pretty well, actually. It was a case involving a franchisee in which the court was looking to other documents, including a comprehensive operating manual and a covenant not to compete that very clearly defined what trade secrets and confidential information were at issue. The part of Rule 65 that the court in Rebath violated was the part that says they can't refer to some other document in describing in reasonable detail the conduct being enjoined. So they've met the specificity requirement in that case. They just did it by referring to another document, which violates a different part of the rule.
In this case, counsel, did you ask for clarification from the trial court or submit an alternative order for the court's consideration?
Did we ask for clarification on the order?
Yes.
No, we did
on the
not.
scope of the injunction?
No, Your Honor, we did not. We appealed from the order immediately.
And you didn't propose an alternative form for the court's consideration either?
I do believe Mr. Stanley proposed a form of order. There was a notice of filing a proposed form of order, which is in the index of record, but I don't recall exactly the terms of it. I know that we did have some objections to the proposed form of order that was submitted by the plaintiff, and we made those objections known not only in our notice of filing a proposed form of order, but in other pleadings leading up to the hearing.
And if we look at your objections, would that address the specificity provision that you're making here on appeal?
I think in part it would, but I don't know to what extent it would, because we, at the time prior to the hearing, we weren't aware that the court was going to use that language. So I don't know how expressly it's stated in our objections, but in this case, the court was very clear that in making its ruling, it hadn't defined what the trade secrets or proprietary information were because it lacked sufficient information to make that decision. So the court is acknowledging, hey, I don't have the information to put the parties on notice of the specific conduct from which they're enjoined, which I think is in direct violation of Rule 65.
But again, did you make the court aware of that, your objection?
Following the issuance
After
of
they
the order?
issued it? I mean, your response to me was that, no, that all happened before the court issued its order. So then my question to you is, after the court issued its order, did you allow or give the court an opportunity to correct the alleged mistake?
As far as I know, I don't think that we have filed a motion for clarification or for reconsideration of the order.
And in your opinion, how could the court have, with greater specificity, identified proprietary information?
So in this case, we're very unsure of what proprietary information is at issue. However, if the parties had said we're worried about certain proprietary information, say something having to do with the way the software as a service operates, or some flow of business or customer information, if they had at least described, say, a comprehensive customer list detailing, the purchasing desires of these customers and things like that, or historical purchases of the customers, that would be reasonably defined. That's defined without telling you what the confidential information is, but it's saying it's a customer list. It's not telling you the names of the customers. So you can get around that the same way you can in pleading a trade secret case. You have to at least, go as far as to describe what rises to the level of a trade secret or what confidential information is at issue.
Well, you're not disputing that there is proprietary information available in this case.
I would say there's probably some things that rise to the level of proprietary information that that the company had at that time. I don't think there was any danger of that information being improperly used or any showing that it had been.
And so if you thought there was information that wasn't covered by what you've determined to be this information, could you ask the court for clarification? Like, okay, we'd like to use this because we don't think this is proprietary.
I'm sure that would be, I guess, an option, but that's not really what the rule contemplates. The rule tries to avoid this type of situation where you'd have to be, fearful that something you might disclose could be later considered proprietary or later considered a trade secret, and you're not on notice that you can't, disclose that to somebody else, or you can't use that because you're not on notice of what proprietary information they're talking about or trade secrets they allege there are. Which leads into the problem with there not being a security issued in this case.
Before you get there,
Sure.
So if we agree with you that one, we have jurisdiction, and two, that this didn't have enough specificity, we just simply remand it for the trial court to enter an order that is more specific.
With respect to the injunction, the trial court could issue an order that defines specifically what trade secrets are and details them in reasonable detail. With respect to the receivership, it should be vacated in its entirety.
And wouldn't your client be in the best position to determine what is proprietary information that should be protected, him being the managing member for the duration of the company?
Well, he's not a lawyer, so he doesn't know what rises to the level of a trade secret or what might necessarily be considered proprietary to the plaintiff, but I would say I agree with you in part that he would be able to determine certain things on his own, like he as a business owner wouldn't want his customers' information or information about the way the software as a service is being used or marketed to other competitors, for example, but that's not really what the rule contemplates. Again, we don't want to have parties going back to the court constantly to say, I don't understand your order. The order in the first instance should be issued with sufficient specificity to survive this type of challenge.
And had your client been confused or needed clarification, don't you think the trial court was in the best position to do that?
No, because the trial court admits that it didn't have any information to do that.
So you say, Judge, you didn't have any information, and he goes, oh, you're right, so let's hold a hearing, and I can determine that. Instead, you appealed an issue that was never really addressed by the trial judge.
I mean, what would the court have done had we appealed and said you didn't give adequate consideration to the amount of the security as well? I mean, the problems with the injunction are twofold. Plus, the court in saying, I don't have the information to follow the rules, so I'm going to issue an injunction and kind of get around the rules by using the words trade secrets and confidential information and not defining them. I mean, that if the court didn't have the information at that stage and they didn't give him the information, I guess we could have technically moved for the court to reconsider the issue, or the court could have held a separate additional hearing. However, the court was required under the rules to have, and it set that hearing on their motion for an injunction for the same time as the hearing on the receivership. So the court set aside time to do it, but it just didn't actually give that consideration that it was supposed to. Well, with respect to the security, we argue that the court failed to require that the plaintiff pay a security before it issued an injunction, and failed to give any consideration of the proper amount of a security. And plaintiff cites the Wilcox case, and in that case, the Court of Appeals held that both Bayham v. Funk and Rule 65 require a reasonable bond be set and paid by the movant, and that the court give significant consideration to the security amount. The Wilcox case expressly states that the court's consideration should be a fact-intensive process, and we believe the court should vacate the order because in this case the court failed to give any consideration to the security amount and failed to require that a security be posted by the plaintiff. And I'm going to, if I can, reserve some time for rebuttal. Thank you.
Thank you, counsel.
Good morning, Justice Winthrop, Justices Campbell and McMurdy. My name is Mark Nadeau, and together with Kate Beneviste, we are with DLA Piper here to represent the interests of Michael MAGNOTTA, appellee in this case. I'd like to begin, if I might, with reference to the order itself and quoting some language to you from it. As Judge Broadman said, simply put, and based on the limited record before it, the court cannot understand how a viable company with yearly revenues of $750,000 could turn valueless essentially overnight unless there was a substantial mismanagement or breach of corporate duties. As noted by plaintiff, the concept of judicial dissolution and preservation of the company are not, repeat, not mutually exclusive. The court finds the behind-the-back August 9, 2016 email to customers particularly troubling. This email was sent after Mr. Serra had announced his intention to resign as manager. There is no evidence that Mr. Serra discussed the email with his 50% co-owner. The email was sent on the same day as a return hearing, and no mention of the email or Mr. Serra's plans to send it were mentioned to the court. At a very minimum, Mr. Serra had an obligation to consult with Mr. MAGNOTTA before engaging in conduct that could have a dramatic effect on the company. The email and the surrounding circumstances reek of bad faith. Indeed, my opposing counsel today has talked to you about a gap when there was no receiver appointed. There was, in fact, a receivership application pending at the very time that this letter went out. And it was because of that that the judge found it reeked of bad faith. We mention that at the outset because, as you all well know, both the receivership and an injunction relate directly to equitable principles, and that's what's called for by the court. To talk about the appeal in two parts, there is the receivership, of course. That order, as you well know, and as you suggested, Justice Winthrop, was entered on August 29th. The time ran for any appeal. Unmentioned, of course, is the notion that that was stipulated to, the appointment of a receiver. They agreed to the appointment of a receiver after having been caught with the notion of the reeking bad faith letter, and they also participated in the naming of the person and the firm that would become the receiver in this case. Having stipulated to it, having an order in place, the obligation pursuant to the statute, as you well know, was to appeal it within the appropriate time frame or to watch that appeal right vanish.
Did the
Until such
expiration
time
of
as
the
a judgment.
Did the
Yes, sir.
expiration of the receivership have any effect on their ability to appeal?
I don't think there ever was an expiration of the receivership. In fact, if you read the order, he talks about the continuing order and pursuant to the first order appointing the receiver. So in this circumstance, we're not talking about a stop and then a new start and a new basis for the receiver. There's certainly supplemented evidentiary basis for it at the time.
Your position is that the stipulation by the parties was not limited to the appointment of a receiver for a temporary period of time that would expire then at the end of that period.
Exactly so, Justice Winthrop. In fact, any receiver appointed by a trial court is temporary. It follows that there will come a time when they are discharged of their duties. And so if it is a continuing order in the process, it is exactly that the legislature has said we can't go back and unwind, and it is exactly that which our appellate courts, this division in fact, have recognized, would put us in an unworldly position where we're trying to unwind activities and actions taken pursuant to the receivership order and put things, the milk, as it were, back in the bottle.
So your position is that any opportunity that appellant had to challenge the appointment of the receiver and appeal from that has been waived?
Correct. At the time that the order was entered, the appeal time began to run. There is no question pursuant to the statute that this court only has jurisdiction at the time of the appointment and to consider whether that was appropriate or not. As you'll appreciate, counsel today proposed to use special action jurisdiction. That's never been proposed until oral argument today. Regardless, you well know that special action jurisdiction in this state is in the nature, in this case, of mandamus. Why? Because if there is something to be stopped, we must stop it quickly so that things do not keep going down the road and the receiver doesn't take action and the court doesn't take action in furtherance of the receivership that then would cause the appellate court to try to unwind it. So special action jurisdiction, having never been waived and no effort to pursue it taken at the time, should not be mentioned for the first time in this oral argument. Regardless, we think it doesn't apply, but more so to the point you well know. It is clear from cases out of this very court, the AEA Federal Credit Union case and others, that your jurisdiction is limited to repealing or reviewing an order of appointment and not for furthering orders. Let us turn then, if we might, to the injunction. There is no authority cited that a trial court must list out all proprietary information and trade secrets as if in an index. You cannot find that in any of the cases. It is common, we suggest, that a court would enter an order that would say, thou shalt not interfere with proprietary information and trade secrets. And why so? Because, as you suggest, A, if there's a question on it, you can seek clarification. More to the point, how does enforcement occur? Enforcement occurs with an order to show cause. And one would be brought in and you would have to presumably demonstrate that the proprietary information was so well known or observed or certain in the company, or that the trade secrets were in fact known by that person or listed within the corporate books and records in some fashion or another, that you have violated the order. A judge at the trial level on a preliminary basis in an injunction setting against the equitable backdrop that we've just discussed, within 60 days of the filing of the complaint, and a hearing and a stipulation on the receiver, and then further evidence in the October time frame, is hardly in a position to list it all out. It exactly is the kind of situation you've described, Judge McMurdy, where certainly one can go back if there is uncertainty about that, and in this case, as you well know, despite comments by our opposing counsel, there was no effort to do that. There was no suggestion of a need to clarify. There was no objection to it on that basis at the time. There was no motion to reconsider filed at the time. Nothing whatsoever. So when you're talking about certainty in this context, then it is enough. It is certain enough that the company, as my colleague agrees, had proprietary information. There was testimony in the trial record, as you're aware, about software. There was testimony about use of the customer list, the clients, to send the letter alone, which is demonstrative of using the company information. There is testimony in the trial transcript concerning the diversion of the assets to the new entity, Apliga. A copy, says the receiver, essentially changing the name from iColigo to Apliga and carrying on with the business and the same customers. No question that the judge had that in mind, was concerned about it, and entered the injunction appropriately, in our view. Next, of course, would be the question of the bond. There is plenty written here in the briefs before you about the question of whether or not there needs to be a bond in this circumstance. If we take as a given that the judge was appointing a receiver to take care of and manage the corporate assets, then by definition, the two members, the 50-50 shareholders, are protected. If we take as a given, as the judge does in his order, and he actually makes specific comment on it, that the former manager, Mr. Serra here on appeal, having had access to all of the data and the information of the company and having been the manager of it, cannot be seen to be taking information consistent, if you will, with the cases holding, such as the Bank of Arizona, the Supreme Court case, that since there was a right of receivership in that case and injunction by way of contract, then here again, if you will, because of the statutes on LLC and our corporate behavior statutes and case law, one can't be seen to be harmed significantly. There was a bond, $5,000 and a receiver appointed. And
The bond was
potential.
in relation to the receivership. It was not in relation to the preliminary injunction. Is that correct?
I think you could take it either way, Judge. Certainly it's in context of the receiver's bond.
Well, who
But-
posted the bond?
The receiver did, but of course,
And doesn't
the
the rule
parties
require-
are generally responsible to reimburse the receiver for that.
But doesn't the rule require that the movant be responsible for posting the bond?
No, I do not think so. That's in the case of, if you take a look, it's an interesting point. If you take a look at the statute regarding dissolution of the corporation, then you get into the applicant issue. Not necessary, and in fact, TROs and injunctions are entered in this state regularly with other people putting up the bond. The bond, let's take a look at it, because it's important, was designed to do what? Assure the performance of the receiver in its duty to protect the assets. So I suggest to this court that it is fair to say the trial court considered the appointment of the receiver and the bond associated with that, which was to protect Mr. Serra and Mr. MAGNOTTA, was sufficient within the context of Rule 65. But beyond that, there's no need for a bond at all. The discretion of the trial court is invoked here to make a decision. And because both the receivership and the judicial dissolution issues are at bay here, and both members who are the only interested parties in that are being protected.
And
Then-
conceptually, I hear what you're saying, but I'm kind of a stickler for words. When we look at 65C, it says the court may issue a preliminary injunction, a lot of verbiage, only if the movement gives security in such amount as the court, and goes on to talk about that. So should we just disregard the language of 65C?
No, but it's the question of in an amount to protect, right? Because 65C, such amount as the court considers proper, okay?
So when
To
we
pay
talk
the-
about amount, are you saying amount can equate to zero?
In certain circumstances, yes. And we have Supreme Court of Arizona saying that, and other collateral cases that you know of.
And so in this case, do you believe the court awarded or required a bond in the amount of zero?
No, because in our view, the receiver was in its own way a bonding over, right? Because it protected the assets, and then the $5,000 was to assure appropriate performance of the receiver court-appointed officer. That's pretty good protection, one would ordinarily say. So if you take those elements, the question is, did the judge abuse his discretion? We've handled, and I'm sure each of you has been involved in cases when you were at the trial level, of bonds that were $10,000, things of that sort. And we've also seen bonds in the hundreds of thousands or millions. These things can happen.
If the judge had said, in light of the bond, I determine, in light of the receiver bond, I determine zero is appropriate, then that's one thing. But that's not what he said in this case, is it?
Well, what he actually said was there will be a bond for the receiver, okay? It is ordered that no bond is required, so that's your zero, okay? That's the language, that no bond is required except for the bond already filed by the receiver. You could conclude, if you wanted, that that's an abuse of discretion, to say that no further bond is required, the zero, is an abuse of discretion. That's a tough call in the circumstances where the receiver is being appointed, where you have bad faith, the equitable issue reeking of bad faith, underlying it, and there is a bond being provided to provide for the protection of your appellant here, Mr. Serra, and his business interests that are presumably the harm that would be at issue. So in that context, this court should find that this judge did not abuse discretion, did comply with Rule 65C, also complied with other case law in this state about the fact that a bond is not required in certain circumstances, and nonetheless that with the appointment of the receiver and the bond posted by that receiver, then there's adequate protection to the interests of Mr. Serra, your appellant here. Thank you, unless there are further questions.
Thank you, counsel.
Okay. In talking about the receivership and jurisdiction to hear that matter today, the court does have can exercise its special action jurisdiction sua sponte. So regardless of whether we had brought it up in our briefs, which we did in the briefs on the opening brief, page 3 specifically, the court can exercise its jurisdiction on its own. And it should in this case, again, because these are issues of statewide significance, pure questions of law, and the record will allow you to resolve these questions of law, especially with respect to the receiverships and when those orders are appealable. Plaintiff points to the Yuma funding case. That case is very different than the case at hand because the order appealed from there is an order denying a motion for reconsideration. So it's not even an order regarding the discharging a receiver. It's an order denying a motion for reconsideration of an order discharging a receiver years before. I think roughly 4 years before. So the type of order and timing of appeal are completely different in the Yuma funding case. In this case, we're dealing with the appointment of a receiver and the temporary receivership. With respect to that, my clients stipulated to allow a temporary receiver to come in and manage the company prior to a hearing, and that was only stipulated to for 7 days. It was supposed to be a 7-day receivership, so temporary in nature that it would expire by its own terms. Then we stipulated to continue that hearing so the receiver would have more time to prepare a status report for the court. And that stipulation, by the terms of that stipulation, the receivership expired September 30th. So we really are looking at 2 separate receiverships. However, the court can still exercise jurisdiction sua sponte, even if it finds that under 122101 it doesn't have jurisdiction. With regard to the specificity and the injunction, the Patriot Homes case that we cited to, it's 512 F3D 412. Sorry, I'm trying to read my own handwriting here. We cited to it in our opening brief, and it's a district court case that says that despite it being difficult to ascertain what trade secrets or proprietary information are, the court must still make this determination and put that language in the order. So there's case law out there saying the court has to have some reasonable determination of what it is. And moving on to the security bond that is required, Justice Campbell, you're correct that the plaintiff is required to pay that, the movant is required to pay that under 65C. The law is very clear there. And not only that, the case law that I talked about earlier says not only must the court give a fact-intensive hearing on the issue and significant consideration to the issue of how much the security amount should be, the court must set an amount for the movant to pay, whether it sets that amount higher or lower under the Wilcox case, which I believe is the one that says you can have it set at 0 if after a fact-intensive determination that's what the court says. But that just didn't occur here. There was no consideration given to that here.
Could the court have considered the bond that was already posted and then say, in light of that bond, I factually determine, based on all of the other things, that I'm setting this at 0?
In light of the bond posted, no, because the bond posted was posted by the receiver, and that has nothing to do with
It's
the
a fact
the
to consider all the facts and circumstances of the case.
I agree. Yeah, the judge is bound to consider all the facts of the case. Yes, but in considering what security amount should that the plaintiff should have to pay, or the move-in should have to pay, rather, the court is not looking to the same. It's not making the same considerations as it is in setting a bond for the receivership. It's making separate considerations about what damages might flow from the conduct that's being enjoined, whereas the receivership is about, protecting the property in the first instance, and that's the equitable principles they cite to. But in this case, as I've stated, there was no property to protect because at the time of the permanent appointment, the judge, the receiver, the plaintiff, everyone said, Icaligo's toast. It can't be resurrected. It has no ongoing business. It's not making any money. The receiver said, I've shut it down. So the fact that the court would order a receiver to protect property is kind of mind-boggling in that instance. And the fact that the plaintiff would have us believe that he has an interest in the company's property would be flying in the face of the LLC Act. We'd be disregarding the principles governing LLCs if we did that, because his only interest is his membership interest. And at that juncture, the court even said there's no resurrecting this company. So there was no way there would ever be a change in Mr. Magnotta's property interest in his membership interest, which is the only property interest he has. Thank you, Your Honor.
Thank you, counsel. We appreciate the briefing and arguments presented by counsel here today. We're going to take this matter under advisement. We'll issue our written decision in due course. With that, we stand adjourned. Thank you.